Thank you, Mr. Chairman. Chairman Gensler, Commissioners, we're glad you're with us this morning. Chairman, over 2/3 of the members of this committee have rejected the Commission's approach to regulating digital assets at the SEC. These bipartisan members collaborated and voted to pass our fit-for-purpose Fit 21 legislation with overwhelming bipartisan support in the House of Representatives, including 71 Democrats. All the commissioners, I think, need to recognize that our ongoing legislative work to establish a market structure for digital assets, while we've been doing that mightily here over the last 2 years, the Commission has time and time again chosen to bring numerous enforcement actions in an attempt to claim authority over secondary markets and front-run Congress. Further, the Commission arguments in regard to several high-profile federal court cases in regard to digital asset oversight have been rejected, and in some instances, your actions called arbitrary and capricious. So, Commissioner Peirce, this regulation by enforcement approach, is it really superior to having Congress give you statutory direction?
It's a very bad approach to trying to regulate an industry if you're trying to protect investors, if you're trying to shepherd the Commission's resources well. It's very inefficient. And at the end of the day, it leaves everyone wondering where the lines of our authority are. That we have lots of areas where our authority is very clear, and we could spend our enforcement resources there, and we could spend our regulatory resources trying to provide clarity about what doesn't fit within our jurisdiction, and then we could leave the rest to Congress.
Commissioner Lizarraga, you used to work for former Speaker Pelosi, and you may have noted that the former Speaker voted to pass Fit 21 this past summer. Do you support this legislation draft and efforts in Congress to establish a regulatory framework for digital assets in the United States?
Congressman, I defer to Congress on its judgment as to whether a new framework for overseeing digital
do you think that the existing framework that the Commission's following is the right way to go, or do you think there's a gap that could be filled by a statute in Congress?
I think we're following the framework that's in place in response to violations of the law that we see in the market. So I think it's something that we're doing in pursuit of our mission and in light of the fraud that occurs in that market. And
well, we all want people to go after fraud, but this is about people who are trying to do the right thing, and they find that an impossible task with this SEC. Commissioner Ueda, the Commission has failed to use its discretionary authority that the chairman noted in his opening statement under Section 36 of the Exchange Act to provide some regulatory clarity in the digital asset ecosystem. What could they have done? Pick an instance where you think that a working example of where the Commission could have used exemptive relief in solving some of these challenges, either these ETP challenges, the special broker-dealer challenges, or the Howey test itself, to have just dealt with this at the Commission using exemptive relief.
Well, thank you. The Commission has a wide range of existing tools that we could use to address the lack of clarity, whether it has to do with the status as a security, or whether it pertains to broker-dealers or exchanges or custodians of these types of digital assets. To my knowledge, I am the only commissioner in the history of the agency who's actually stood before a panel of judges in oral argument and articulated the Howey test after having filed a written brief with that court. One of the things, so the Howey test is an investment of money in a common enterprise with the expectation of profits from the efforts of others. That's from the Supreme Court. Numerous other circuit courts have elaborated what exactly that means. The Commission, for instance, I'll give you one example, could have articulated specifically in the context of crypto and digital assets how you apply this test as to whether or not it's an investment contract and therefore a security. We've done that before. For instance, to explain what fiduciary duty means under the Federal Investment Advisors Act. We have chosen not to go down that path. And right now, I've been with the Commission for 20 years, or for, 18 years. I've been a securities regulator for 20 years. We are now entering into our second decade of thinking about this issue. It first popped up on my
Thank you, Commissioner. My time has expired. I yield back, Mr. Chairman.
Gentleman yields back.